I guess the first order of business should be everybody turn your phone off. Unfortunately, usually silencing is enough, but apparently some phones may go off for a period of time while the emergency alert testing is going on. So if you would, if you've not already turned it off,
All right, I guess I better turn it
please do. That includes justices
That's right.
too.
'Cause I say-
All right. We have some great afternoon cases, and we're such good lawyers here. We're pleased to have you. Welcome back, everybody, in person and on the live stream. Mr. Hebner, would you call the first case?
Vanessa Colley versus John Colley.
Good afternoon, Your Honor.
Afternoon.
May it please the court, Daniel Horowitz of the Nashville Bar on behalf of the appellant, Miss Vanessa Turner. I'm here with my co-counsel, Lindsay Smith and Melissa Dix. I would like to reserve 5 minutes for rebuttal, please. Your Honors, this post-judgment litigation presents two merits questions. First, was Miss Turner the prevailing party under Tennessee Code Annotated Section 365-103C when her ex-husband voluntarily dismissed his post-judgment claim, seeking to terminate his alimony obligation prematurely? And second, was Ms. Turner the prevailing party under the terms of the party's marital dissolution agreement when her husband non-suited his post-judgment claims? I will candidly acknowledge, concede even, that if this matter involved original litigation rather than post-judgment litigation, this would be a more complicated case. This is not original litigation, though. Instead, it is post-judgment litigation that follows earlier litigation in which Ms. Turner became the prevailing party by winning both a judgment on the merits and a consent decree requiring Mr. Colley to pay her alimony. And given those circumstances, this case is easy. This court should answer the questions presented by holding that because Ms. Turner prevailed in the party's original litigation, she did not need to win on the merits again to maintain her prevailing party status when defending against Mr. Colley's post-judgment efforts to modify the court's original decree.
Mr. Horowitz, I understand your point that this is maybe in a different posture because it is post-judgment litigation versus original litigation. But is some degree of finality still needed even when you're talking about, what prevailing means in the post-judgment context? I mean, certainly a court, rejecting on the merits an attempt to modify a consent decree or an earlier judgment would count as prevailing, but that's not what we have here. What we have is a voluntary dismissal. So why is that sufficient, and what authority can you point to?
Sure.
That's the most analogous?
So the answer is no. You don't need a second final merits ruling because when you've already won something in original litigation, your goal in post-judgment litigation isn't to change the legal relationship between the parties again. Instead, it's to preserve your earlier win, period. Now, the case that I'd point you to, we've cited the Sixth Circuit's decision plus a host of federal cases, but the general premise is once you have won, whether it's an injunction or some other relief through a consent decree, and there is some post-judgment effort to modify your earlier win, you do not need to prevail on the merits again.
Mr. Horowitz, what if the person seeking to modify the earlier win won the second time? Then that changes the prevailing party, doesn't it?
Sure. If the party seeking to modify the earlier decree wins on the merits, then yes, the prevailing party status would change. That is not what happened here.
Because I know that, and we have a
But yes,
dismissal here.
that would obviously be a different outcome than somebody who has gotten an earlier win, is trying to protect that win from a post-judgment effort to modify it, and that post-judgment effort does not succeed because of a non-suit or any other non-merits ground for dismissal.
So anything, tell me if I'm stating your position correctly here. So anything that preserves the status quo of the earlier judgment is sufficient to constitute or to satisfy the prevailing party test.
Certainly,
Would that be accurate?
Yeah, if you keep your win in place, you have maintained your prevailing party status. And the basic issue here is you've already won prevailing party status, and a post-judgment effort to modify that status that is not successful, you don't need to win on the merits again. The party's briefing proposes a host of different standards to consider when answering the questions presented, but before diving into those standards, I want to emphasize again the simplest and narrowest ground available for you to rule in my client's favor here. The narrowest correct ruling available is for this court to hold that a party who previously secured prevailing party status in original litigation need not win on the merits again in post-judgment litigation to maintain their status as the prevailing party. Now, that standard makes sense in the context of Section 36.5103C specifically, which is almost uniformly concerned with post-judgment proceedings rather than original litigation. It also makes sense under an MDA, which is definitionally intended to govern post-divorce disputes. That standard is also consistent with the rule under federal law that we just talked about, which does not require earlier winners in original litigation to win on the merits again in post-judgment litigation to maintain their prevailing party status.
Mr. Horwitz, you're confusing me when you say win on the merits again. We're not addressing the merits a second time, correct?
We're saying that you don't need to address the merits or to have secured another merits victory
Right.
in order to maintain your
I
own.
understand what happened here. You had a non-suit.
Right, that's correct. But to quote from the Sixth Circuit's decision in Binta B. ex rel. SA versus Gordon, quote, an earlier judicially sanctioned change in the party's legal relationship through a consent decree can be the basis of a plaintiff's prevailing party status. Again, after that initial determination, plaintiffs are not again required to establish prevailing party status in the conventional sense of requiring a judicially sanctioned material change in the legal relationship of the parties. In other words, if you prevail in original litigation, you do not have to win on the merits a second time to maintain your prevailing party status going forward.
Can you point to a precedent? Doesn't have to be from this jurisdiction, could be federal precedent or another jurisdiction that involved a voluntary dismissal in the post-judgment context?
Just in general, I'm sorry, I may have
A
missed it.
voluntary dismissal, so post-judgment context, like here, but that involved a voluntary dismissal of an attempt to modify that judgment in some
Sure.
respect.
So, and we talked about this in our response to the Attorney General's brief. There are basically three ways that the U.S. Supreme Court's standard on this have been interpreted. One of those standards deals with voluntary dismissals with prejudice. The other one, voluntary dismissals without prejudice. It's that Iowa case. And the third is I believe what you're probably getting at here, which is that judicial imprimatur language that I think the 11th Circuit has said is necessary here. But to answer your question, it's the outcome, right? So it's the Supreme Court's decision from 2016, that CRST case. Not a voluntary dismissal granted, but certainly an outcome that was not merits-based, right? And that defendant was a prevailing party there, was considered a prevailing party because defendants and plaintiffs come to litigation with fundamentally different objectives. Going back to this rule, right, that if you prevail originally, you do not have to win on the merits a second time. If you apply this narrow, widely accepted, uncontroversial, and straightforward rule to this case, then my client wins. There is no serious doubt that my client prevailed in the party's original litigation, which is not something that Mr. Colley himself has even contested. Just to recap the outcome of the original litigation, in the party's divorce proceeding, Ms. Turner won a merits judgment. She had her cause of action sustained, and she secured a consent decree that required Mr. Colley, among other things, to pay her alimony. Thus, in the party's original divorce litigation, Ms. Turner prevailed because she secured a judicially sanctioned change in the party's legal relationship on two fronts, both a merits judgment and a consent decree. Given that, under the narrow rule for post-judgment prevailing party status that we have proposed here, Ms. Turner did not need to win on the merits again when defending against Mr. Colley's post-judgment effort to terminate his alimony obligation prematurely. Instead, all she had to do was successfully oppose the relief that Mr. Colley sought, which is exactly what she did. I also want to emphasize that unlike Mr. Colley's position here, our position on what the term prevailing party means is firmly in line with three separate strands of Court of Appeals precedent, most of which you would have to overrule to rule in his favor. First, in the discretionary cost context, Court of Appeals panels interpreting Tennessee Rule of Civil Procedure 54.041 have uniformly held that a defendant is a prevailing party when a plaintiff non-suits. That's the J.P. Morgan Chase line of cases, and we've cited several of them. Our position comports with that precedent. By contrast, the Appellee's position would require you either to overrule that precedent or else to hold that the same term, prevailing party, means something different depending on whether you were talking about discretionary costs versus attorney's fees. Also note that you would not only have to hold that the same term means something different, you would have to hold that the same term means something different in the same context. That makes absolutely no sense. As the United States Supreme Court held in Ochai's Consultancy versus United States, 2019 case, quote, "In all but the most unusual situations, a single use of a statutory phrase must have a fixed meaning. We therefore avoid interpretations that would attribute different meanings to the same phrase." Here, unless you are willing to overrule a long-standing line of Court of Appeals authority, that is exactly what you would have to do. This court should avoid that result, which would also cause mass confusion for parties who have contracted based on Tennessee court's long-standing interpretation of a common phrase. Second, at least 3 Court of Appeals panels have held that defendants may recover attorney's fees under Section 365-103C when plaintiffs voluntarily dismiss their claims. Those cases are Pounders versus Pounders, Hansen versus Hansen, and Hayes versus Scoggin. I don't know if I answered your question earlier, or I interpreted it as only under federal law. These are the cases under Tennessee law. We've cited all of them in our briefing. Also want to emphasize that 2 of those cases, Pounders and Hansen, predate the 2018 amendment to Section 365-103C, which expanded the circumstances in which recovery is available. As a result, if you apply the rule that the legislature knows the state of the law when it amends a statute, then this case is over, because the state of the law under Section 365-103C at the time when the statute was last amended was to allow beneficiaries of non-suits to recover their attorney's fees. Third, in Williams versus Williams, 2015 Court of Appeals case, the Court of Appeals held that a second court-ordered judgment is not a prerequisite to prevailing party status in post-judgment litigation. That case involved an ex-husband who was willfully violating the terms of his MDA. His ex-wife then filed a petition for contempt to secure compliance. On the eve of hearing, ex-husband did what he was supposed to do all along, thereby mooting the case. Ex-husband then insisted that because his ex-wife hadn't secured a merits judgment or a consent decree in their post-judgment litigation, he should not be on the hook for her attorney's fees despite his clear misbehavior. Upon review, a majority of the Court of Appeals disagreed. And while they didn't say it in exactly these terms, the effect of the holding was to say that the plaintiff there, who had initiated post-judgment litigation to enforce an earlier win, did not have to prevail on the merits again to secure a fee award. In other words, they rejected the exact position that the government has advanced here.
I want to ask you a question, Mr. Horowitz. So the state is concerned that your interpretation of prevailing party in the context of this case is going to have a lot of spillover effect, even with the more narrow interpretation that you're talking about, limited really to facts of this case where your client prevailed in the original underlying litigation. Is there still cause for concern that that will bleed over into other? This is obviously a marital case. They kind of have their own patterns of repetitious litigation, spouses against one another. But the state is obviously concerned that this is going to bleed over into other cases. How valid is that concern? And if it's not valid, why?
I think it's not valid. I also just want to just emphasize what the state's position actually is. They don't take issue with the narrower ruling, right? If you turn to page 21 of their brief, they say, while an earlier judicially sanctioned change in the party's legal relationship through a consent decree can be the basis for prevailing party status moving forward, that is only true when the pre-existing consent decree creates a prevailing party. So they said that just didn't happen here. Now, nobody involved in this case has actually taken that view. It is not correct. My client was clearly the prevailing party on both fronts. She secured a merits judgment.
Well, clearly they were, I mean, everybody knew on the front end that's the facts of this case, and yet they felt the need to weigh in.
They got the narrow question wrong on the facts. As to the broader question, I guess I would answer it in a couple of ways. So first, the Court of Appeals for years, right, has said that, at least in the discretionary cost context, a beneficiary of a non-suit is the prevailing party. And under this specific statute, the Court of Appeals at least 3 times has said that the beneficiary of a non-suit is a prevailing party. So I don't know about the spillover effects. I don't know about whatever concerns, but this has been the state of the law for a while now. You'd have to change the law in order to modify the status quo. But this has been the law for at least 2 decades, both under this statute and in the discretionary cost context.
Well, doesn't it create a pretty strong, a rule like the one you propose, create a pretty strong disincentive to any party who might want to seek a modification or, vacation of an earlier judgment?
No, I think the opposite, right? So if you have a valid basis for seeking a modification and that valid basis is opposed, then you can go and seek a modification with the assurance that your fees will be paid. I mean, that's one of the benefits of this rule, is it encourages defendants who are on the receiving end of a valid claim to behave nicely. So that's exactly what happened here. This petition, among other things, was filed in January based on a claim that in March the alimony obligation should terminate. I'm just pulling up, it's on page 26 of the record, paragraph 22 of the answer, right? Saying that other than terminating the alimony obligation, alimony and life insurance requirement when she remarries in March 2019, to which she will agree and would have agreed with if asked without filing a petition, basically she's doing what she's supposed to do here. If you're a defendant on the receiving end of a valid claim, you have every incentive to behave, play nicely, and stipulate to the validity of that change. What it deters are bad faith claims, because if you maintain a bogus claim for modification, the other side is going to get their fees paid.
Well, or if you maintain a claim, if you bring a claim for modification, if you file a motion to modify and circumstances change and you voluntarily dismiss that without prejudice, not in bad faith, but for some other external reason, you're on the hook for attorney's fees.
I guess I would have to know what the external reason is that changed the validity of the claim from its filing until the non-suit, but I think by and large, the concern is on the opposite side, right? Especially among poor and vulnerable litigants who cannot afford to defend the validity of court orders and previous decrees without the assurance of fee shifting. I mean, what you're gonna do is encourage a lot of bad faith claims to be brought and require defendants who cannot otherwise afford to defend themselves to roll over and capitulate. I mean, it's the policy consequences here go in exactly the other direction. Ultimately, though, the question becomes, why would you overrule this existing precedent discretionary cost context under this statute specifically, post-judgment context? According to the Appellee, the reason is this court's 2012 decision in Himmelfarb versus Elaine. Himmelfarb was a malicious prosecution case, though. Never even mentioned the term prevailing party. Whether a defendant has been maliciously prosecuted and whether a defendant has prevailed in litigation are also fundamentally different questions that don't even relate to one another. As the US Supreme Court explained in CRST, common sense also undermines the notion that a defendant cannot prevail unless the relevant disposition is on the merits, which is the exact standard from Himmelfarb that the Appellee has asked you to apply here. Given that, this court should reverse the panel's judgment, which relies entirely on the conclusion that Himmelfarb controls.
Let me ask you just a question about the contract. There's both a statutory provision here and a contractual attorney's fee provision. Is your argument regarding the interpretation of prevailing party the same with respect to both of those? Is there any daylight? I mean, when I look at the statute, there's the term prevailing party, but then there is the surrounding context, which I think also supports your interpretation of that. We don't have that same surrounding context when it comes to the contractual provision.
Sure. Let me answer that in a couple ways. So first, I think for the exact same reasons as the statutory claim, I think they apply to the MDA here, right? That you don't have to win again. But I do think the contract claim is easier for at least three reasons. So first, just applying the usual, natural, ordinary meaning of prevailing party. Defendants are prevailing parties when a plaintiff dismisses his claims. In common parlance, a prevailing party is not a litigant who can satisfy the favorable termination on the merits element of a post-Himmelfarb Tennessee common law malicious prosecution claim. Just to say that out loud is to prove it. Lay people's natural and ordinary understanding of the term prevailing party does not include phrases like judicial imprimatur, which is not a word that most people know and which I myself did not know how to pronounce until preparing for this oral argument. All the authority, so this is the second issue, all of the authority that has been marshaled against our contract claim postdates the party's MDA here. At the time of the party's MDA, at the time it was executed, what the parties did have was this line of Court of Appeals authority from the discretionary cost context, holding that defendants are prevailing parties when a plaintiff non-suits. And because laws affecting the construction of contracts enter into its terms as if they were incorporated, Ms. Turner had a right to rely on the Court of Appeals' consistent interpretation of prevailing party when submitting to a consent decree and certainly when drafting it. And third, there is a specific statute in play. Tennessee Code Annotated Section 20-6-301A provides, quote, if a plaintiff voluntarily dismisses an action while a counterclaim is pending for contractual attorney fees, and if the plaintiff does not timely recommence the action, the court, upon proper showing, may order that the counterclaimant is the prevailing party for the purpose of recovering contractual attorney fees. That statute applies here. Mr. Colley voluntarily dismissed his action while Ms. Turner had a counterclaim pending for contractual attorney's fees, and he did not timely recommence the action afterward.
How should we sequence these questions in your view?
This court's authority has said you consider the contract claim first, so I think that would be appropriate. I think the statutory claim is the simpler among the two, and I don't know that you necessarily have to answer both. We're certainly happy to win on one ground and not have the other ground addressed. That's the same relief regardless. But I think this court's precedent from Eberbach, I believe, says you address the contractual claim first.
Mr. Horowitz, excuse me, the statute that you cite, 26301, it requires a proper showing. What does that mean?
I think you have to show that there was a contract in play with a fee shifting provision that applied to both parties, and that's been more than a year since the litigation was non-suited, and that as a result you're entitled to fees under the statute.
That's all there is to it. There's no, in your view, there's no requirement of bad faith or improper use of litigation?
No, Your Honor.
All right, and so my other question has to do with Rule 41. There's a policy that we've had in this state for a long time to allow a plaintiff to withdraw a cause of action, to voluntarily dismiss a lawsuit at his or her own choosing. Does your position in this case that a non-suit creates a prevailing party run counter to that?
I think it does not, for a couple of reasons. So first of all, there's nobody's saying that you can't non-suit, right? They still have the right to non-suit.
You just have to pay the fees, right?
You have to pay the fees if you have lost an original litigation, been subject to some kind of consent decree that you were unsuccessfully attempting to modify, then yes. But secondly, the incentive is the same regardless. In fact, it applies earlier. This deters bogus claims from being filed in the first instance, right? And this policy gives you a strong incentive at every stage of litigation to get out as quickly as possible if your claim is not valid. It also encourages plaintiffs to maintain small dollar claims that otherwise would not make any sense. Because if you win them, and it's a valid claim, you get your fees on the back end. So the policy here, I think, is clearly benefiting this limited fee shifting that we've asked for here. I recognize that let me get into the policy, because I know members of this court have slightly different approaches to considering policy consequences when interpreting statutes, but I think it's worth discussing here for a host of reasons. A ruling for the appellee would have some pretty unpleasant and predictable consequences that I think should give you pause. Most prominently, the fact that court orders will go chronically undefended by vulnerable litigants who cannot afford to defend them without the assurance of fee shifting. Consider, for example, a woman whose ex-husband has been ordered to pay her alimony and child support. Despite his obligations, though, her ex-husband refuses to pay, something that is all too common. That woman now has to go hire an attorney, file a contempt petition, and incur attorney's fees to force her ex-husband to pay what he owes her. After she incurs those expenses, though, deadbeat ex-husband can evade a merits judgment just by paying whatever he was supposed to pay to begin with. Doing so instantly moots the litigation, and the contempt petition must now be dismissed for lack of subject matter jurisdiction since there is no continuing controversy. Under these circumstances, if you accept the appellee's position, or if you do what the Attorney General has asked you to do and require courts to have made some kind of independent decision regarding the litigation, then deadbeat ex-husband evades a fee award, and aggrieved single mom is stuck with legal expenses for enforcing the court's order, legal expenses she should never have had to incur at all. That is a preposterous outcome. It's also very close to what actually happened in Williams. And if the dissent's view in that case had carried the day, you would see a lot more bad faith in the family law space and many more court orders going undefended by litigants who can't afford the expense unless they can be assured that they will recover their attorney's fees at the end of the litigation. This case is perhaps somewhat less extreme, but it's not any less sympathetic. Just as a reminder of what led to this dispute, Mr. Colley initiated this action to terminate his alimony obligation to Ms. Turner prematurely. There was no legitimate basis for doing so, so my client retained counsel and defended herself against a bogus claim for nearly 2 years, which Mr. Colley then non-suited 12 days before trial. She also spent more money defending herself than she would have spent if she had just capitulated to the bogus claim and foregone her right to alimony. Given that, if the message that this court wants to send to beneficiaries of alimony awards or child support awards is that they cannot be assured that they will recover their fees if they seek to enforce those awards, that they should just roll over under circumstances like this because it's going to cost more to defend the court's order than give some bad actor exactly what he wants, then by all means, rule for the appellee here. But it's terrible policy. It will have terrible consequences, particularly for those who are most vulnerable and can't afford to defend court orders without the assurance of fee shifting. Also note, if I might finish my sentence, court orders can't defend themselves due to party presentation rules. Courts have to rely on litigants to defend them. And if vulnerable litigants cannot do that, then these court orders will go chronically underdefended. Thank you for your time.
Good afternoon. If it may please the court, I'm Marlene Boshears of the Williamson County Bar, representing the appellee, John Colley, in this matter. And I think something that was not argued by Mr. Horwitz, was not argued necessarily by me, but that I think the court must consider is whether or not the trial court even had subject matter jurisdiction at the time of the entry of the order of attorney's fees, since that can be brought at any time and cannot be waived. Whether or not the court had that based on the filing of the non-suit. If you look at the dates very specific to this case, the notice of voluntary dismissal was filed by my client on November the 6th, 2020. 2 days later, on November the 8th, 2020, the appellant filed a motion for sanctions for abusive lawsuit, or alternatively, a motion to alter or amend the dismissal order. However, the dismissal order had not yet been entered, because it was not entered until November the 13th, 2020. So essentially, a Rule 59 was not appropriate there, because if you look at the specific language of Rule 59, it says a motion to alter or amend shall be filed and served within 30 days after the entry of the judgment. So there would have had to be some order to have been requested to alter or amend. Those two reasons are the basis of why the trial court, in fact, was able, or one of the bases that the trial court was able to award Ms. Turner her fees, her attorney fees. And that's because the court said, no, we deny the motion for sanctions, but we're going to alter or amend that dismissal order and allow you to file a motion for attorney's fees. And those are the facts of this case. So whether or not after the notice of dismissal and after, in between, if that was filed, does that carry over past the non-suit under Tennessee law? Because if that question answers and it does not, the rest of this, as far as the prevailing party, doesn't really matter. The reason why we say is no, because the motions for sanctions was denied and it was untimely on the motion to alter and amend. We also say no, it does not survive the non-suit, because case law is very specific in Tennessee, a whole lot of case law specific in Tennessee, and says there are exceptions to when, exemptions or exceptions to when a non-suit is not able to be taken by a plaintiff. None of those are in this case. It is not, only the first voluntary non-suit that was taken. There wasn't a summary judgment motion pending. There had not been submitted to any jury for deliberation. There's certainly not a class action lawsuit, no receiver appointment, and there is not a separate statutory exception or exemption that expressly says a plaintiff can't take a non-suit in this. There is also no implied vested right that it was acquired during the pendency of the suit. And that is because the case law says very clearly that those motions that are pending do not survive non-suits unless there is an exception or in other rare circumstances that those vested rights can occur. Specifically, those cases, very recent cases, some of those, as recent as September 28th, so 2023, that's the most recent one I could find for you, pretty recent there. And that is a case of Westfield versus Embry. And it was where a motion to dismiss was filed, but hadn't been responded to nor heard by the judge on its merits. The Court of Appeals held pending motion to dismiss does not preclude the plaintiff from voluntarily dismissing under 41.01 action, and specifically says the defendant's request for attorney's fees did not create a vested right, preventing the plaintiff from taking voluntary non-suit.
Are you supplanting your argument on the merits of prevailing party with this argument, or what?
I'm having both arguments alternatively, Your Honor, if I may.
Okay.
And again, the other cases, there's been several cases, the Flade versus Shelbyville case, the Adamson versus Grove case, both of those kind of go together. They're involving TPPA petitions, one that was filed before the non-suit and one that was filed after the non-suit. The one that was filed after the non-suit said the court did not have any jurisdiction to consider it and dismissed it, and that was the Adamson versus Grove case from November 30th, 2022, Court of Appeals. The Flade versus Shelbyville case actually was already filed, and the petition, the TPPA petition, was pending when the court entered the order of dismissal. But again, the Court of Appeals has found no vested right to seek a dismissal with prejudice, attorney's fees, costs, and sanctions, because that's not a substantive right. It is only a procedural one.
I'd like to ask you a question on the
Yes, ma'am.
prevailing party issue.
Yes.
In interpreting either the MDA or the statute, which deals particularly with family law cases, from being on the Court of Appeals a number of years, in the family law context, repetitive litigation by one spouse who may have a lot of financial resources, be required to pay alimony or child support in an amount that he or she does not like. In looking at a lot of these records, it is shocking how many times repetitive litigation is filed to try to bat down an alimony or a child support order that the spouse with financial resources does not think was right or just to begin with. How do we reckon with that? That is, I mean, certainly the legislature would have known about that when they enacted this statute specific to the family law context. How do we deal with that? That's often the other spouse has little in the way of financial resources. They have to participate in discovery. They have to take off work. They have to get child care. They have to hire a lawyer that they can't afford. And then the spouse with financial resources can voluntarily dismiss and then refile a month later. Tweak the basis a little bit and refile it a month later. And this happens over and over and over again. So how do we interpret the statute or the MDA in a way that is consistent with that experience?
Justice Kirby, I believe we already have a couple of measures in place under Tennessee law for those protections. It does unfortunately happen a lot in the family law context. I agree with you. But we have only a limited number of non-suits that can be taken before it is on the merits. So there's already that under 41.01. But there's also the abusive...
It's usually not the same claim. It's a little bit different. And in family law context, all you have to do is claim slightly different changed circumstance to be able
Or that happened a little later,
Yes,
a month
yes.
later. or
Yeah,
something.
because lives go on and these parties keep fighting. So how do we deal with that in light of that real world experience?
We also have the abusive lawsuit statute. It is there. And it's been used a lot. Even in this case, it was brought by Ms. Turner in this case.
She had to
trying
hire a
stay-
lawyer to do that, right?
What was already pending, she already had a lawyer. It was not, that was at the end of it after the non-suit occurred.
Would you agree that a non-suit with prejudice would qualify, I guess, the defending party as a prevailing party?
I believe that there's case law that suggests that, yes, Your Honor.
So your argument really is limited to this specific context of a voluntary non-suit without prejudice.
Yes. The facts of this case do support that.
If you had tried this case and the decree was left intact, then practically speaking, what's the difference than a voluntary dismissal without prejudice?
Well, I think what we did in this case and the facts of this specific case are that that our client filed a petition for modification of the transitional alimony and the marital dissolution agreement based on what he believed were the fiance and Miss Colley at the time living together. What happened is less than 90 days after he filed this January 2019, she got married to her fiance. She then, even in her own answer, concedes, I agree, once I get married, you don't owe this anymore. So what it did is it made 2 out of the 3 remedies that my client was seeking be a moot point. So my client decided at that point in time, one of them was involving a tax issue from 2012 where he believed he had some reimbursement owed from Ms. Colley. However, looking at it from a judicial economic standpoint, it didn't seem worth it to keep going and litigating and going to trial when 2 out of the 3 issues he had moot by her actions. Essentially, if you're even looking at who would have won or could have won, he won 2 out of his 3 issues. In fact, he no longer had to pay the $5,000 a month in alimony, which, considering the time length it was in the marital dissolution agreement, saved him $200,000.
Is that in the record?
Yes, Your Honor.
So could we get back to my question?
Yes, Your Honor.
So if you all tried this case and the marital dissolution agreement was left intact, practically speaking, what is the court rules, no modification. What is practically the difference between that and a voluntary dismissal without prejudice?
Well, you can't file if it was adjudicated on the merits of the case. You wouldn't have a chance to refile. That is the provision of 41.01 to allow.
Except, as Justice Bivens pointed out, meanwhile, these parties have been living their lives, and they've had more disputes and more issues come up. And so the same basic structure gets filed with a little tweaking of the basis over and over and over again, even if it's dismissed on, even if a judge hears the case and says, I'm not going to modify. It can be refiled a month later in slightly different form. How do we deal with that?
Our courts have the ability to sanction. Our courts have the ability to, again, find abusive lawsuits. And our courts, to some degree, have the ability to limit that. Unfortunately, in family law cases, it's different than other civil cases out there because of the highly contentious nature of them. I have seen that in court. I have seen the trial courts try to even order where there has to be a length of time before you can file something else, and had that appealed and lost. So I don't have an answer to necessarily how to address that public policy concern. But I think there's additional public policy concerns that do arise if it's treated as Mr. Horowitz is arguing today. If every prevailing party in the initial lawsuit does not have to be a prevailing party found in order for attorney fees in a subsequent lawsuit, that is to enforce, alter, amend, modify, then, or to change in some way the former order of the court, then you have, if they're always going to be stuck with those fees, if they don't win, you're going to have a lot of people that do the opposite thing, and they really need to file for the protection of their children, for the fact they are not receiving alimony or child support, but there's going to be a fear that they can't file. There's also going to be a fear of not non-suiting a case when you have a moot issue or some other reason that is a legitimate reason. And the Himmelfarb versus Lane, the Supreme Court, you all at that point in time addressed some of those public policy concerns in that case. So I think there are three kind of public policies at exactly what you said, Justice Kirby, which is trying to keep people from using the court system against another party in a contentious matter again and again and again and again, simply because they have more money, more time. And also the public policy about we don't want to have all of these lawsuits that do need to be voluntarily dismissed hanging around out there. We also don't want the issue of a potential loss without a finding of a prevailing party to mean that people who need to file those will not file those.
Well, as long as we're identifying public policy, hasn't the General Assembly expressed the public policy of this state by adopting 365103C that specifically applies in the domestic context, that attempts to address the very issues that Chief Justice Kirby's talking about? And if that's the public policy of the state, wouldn't that favor Ms. Colley's position in this case?
I don't think, because I think at the time, my argument would be at the time that 365103C was enacted, and it was very recently modified as well and changed, and that's based on, I know that criminal contempt actions used to not have a recovery of attorney's fees. So we certainly have that changed in the last few years. It's after the Himmelfarb versus Lane decision regarding non-suits and public policy related to that, and stating prevailing party is still the language that is used in that. And that means that the judge has heard it. That means the judge has decided on the merits of the case. And that allows for somewhat the other side, if they are merely bringing a lawsuit that is just meant in some way to harm the other party, it has no merit to it, in order to try to make that not happen as much, we have the opportunity through this statute to find the other party, the prevailing party, when it is not granted and have to pay those attorney's fees. But if it's never going to be determined and not have to be determined at any subsequent action because the prevailing party in the beginning is the only one that can win, and absent someone else changing that position, they always get the win. It seems you're going into a second legal action with an unfair disadvantage. I also think sometimes, as Himmelfarb also points out, sometimes it's best to go back to the actual ordinary and plain meaning dictionary definitions. And certainly looking up the Blackwell's Dictionary of Prevailing Party, that's one of the parties to a lawsuit who successfully prosecutes the action or successfully defends against it, the prevailing on the main issue, though not necessarily to the extent of the original. And then if you look up Webster's, it says to gain ascendancy through strength or superiority to triumph. If you look up Oxford's definition, to prove more powerful than the opposing forces to be victorious.
So can I ask you a question about your policy argument that your client voluntarily dismissed for good reasons and shouldn't be dinged for it? Isn't the statute permissive and not mandatory, so that the trial court could take that into account? You would be able to go to the trial court and say, this was not abusive litigation, and he voluntarily dismissed. When it became untenable, that's a responsible thing to do. Your Honor, you should not, in your discretion, award attorney's fees. Isn't that allowed under the statute?
It is in the court's discretion, absolutely. I also wanted to point out that under the statute about not refiling 26301A, cited by Mr. Horowitz, it also requires a counterclaim. And the counterclaim, it says counterclaim and counterclaimant. In this case, we contend that the appellant was not a counterclaimant. There was no counterclaim filed, and in fact, what the trial court essentially did was say because there was relief sought in the answer that requested attorney's fees, that survived the non-suit and essentially acted as a counterclaim in this cause. And the definition of a counterclaim, as explained in the Blake case, simply does not fit that definition in this cause. So I think there are a lot of issues in this case dealing with public policy, dealing with non-suit specific to just the facts of this case and our general precedent of allowing plaintiffs to basically non-suit up as much as they want up into a point, I guess, for most any reason unless it's exception or exempt. We allow the plaintiffs to be the captain of their own lawsuit. We allow the plaintiffs to decide what is best and not best since they're the ones that brought it. It's also got the issues of whether or not there's subject matter jurisdiction that the court even had to do an order. There's also the issue
Did
of...
you raise that argument in your brief at all?
I
was
did
having
not.
trouble locating it. I just wanted to make sure I hadn't overlooked it.
No, Justice Campbell, because it is a subject matter jurisdiction argument, I believe it can be raised at any time, and no, I did not. And then, of course, there's also the issue of whether or not, because what basis was the attorney's fees once a non-suit was taken in this cause, if the court had the jurisdiction to do so, it would have had to be done from a counterclaim or a motion that was already filed prior to the non-suit being taken. And in this case, neither of those occurred. Unless, in fact, we're going to say that every answer that has a general request for attorney's fees, in fact, counts as a counterclaim. And if that's the cause, that's an entire another Pandora's box as far as public policy and issues go, because you're going to, I think that's going to be bad law that gets made, simply because we also say for such general and further relief to which they may be entitled at law. That is a common thing in all petitions, not just for attorney's fees, but for that. And so if we say that the answers can stand alone as a counterclaim, and that's what happens, and that's what the trial court did in this cause, then we're also going to be opening that up to being able to basically have judges rule anything on those counterclaims without due process notice to the defendant of said counterclaim. And going back to Mr. Horwitz's argument that you don't have to win again to keep the status of prevailing party without having, you can have it when judgment is not on the merits of the case. There wasn't a judgment in this cause. A non-suit is not a judgment. A non-suit, the order of dismissal on a non-suit is merely procedural in nature. It's merely a stamp of approval. It is not something that there's been any argument before a court to make a judgment. And
but the same would be true for a voluntary dismissal with prejudice, would it not? And you've said a moment ago that you would agree that that obtaining a voluntary dismissal with prejudice would allow someone to have a prevailing party status.
it would, but there would have
So
been.
what rule, I guess, what rule would you, what rule are you proposing to distinguish between those sorts of rulings that would entitle someone to prevailing party status and would not?
I think there's an attack on the pleadings at the point of a motion to dismiss, a summary judgment motion to dismiss. And so something was done wrong. Or at that point in time, there's just, once you apply the facts to the facts of the case to the law, in the beginning, or it was filed in some way that was done wrong. Those motions to dismiss would then survive if it was a dismissal on the prejudice, with prejudice, had to have been a reason that it was dismissed. And one of those things might be that it could be that there was a moot issue that occurred. Child turned 18, for example. you don't need to have a custody plan anymore. That would have still had a reason to be filed in the beginning, but if it had taken so long and a child turned 18, then you wouldn't have an issue anymore. So the court could, at that point in time, dismiss it with prejudice. But hopefully at that point in time, would just be dismissed voluntarily as well. The distinction I see is that when you non-suit voluntarily and have it without prejudice, it is because you had a valid lawsuit with merit, but something was just not ripe or ready in that lawsuit. So you wanted to wait and potentially file it again within your statute of limitations to do so. Maybe you needed to add a defendant to it. Maybe you needed to get more information to add to your initial petition or modification or change of custody. Maybe you had some other reason. Maybe your client got sick and you wanted to non-suit so they could have cancer treatment. There are a lot of reasons that voluntary non-suits are taken. And based on those reasons, which is individual to every case, it's presumed without prejudice that it was a merit filing in the beginning. There was a reason that was legally sound to file it, whereas with the prejudice, it was not. That's a distinction I see. And I also just arguing again on the public policy with specific to this case and the non-suit. Think you would have a lot of cases that would be out there where people would not non-suit if they knew they were going to be stuck with attorney's fees, even though there are reasons to do so. And that's going to bog down, of course, the court systems to have to do with prejudice dismissals, or they could then potentially, could or could not, because it's within the discretion certainly of the court to award the attorney fees. If it remains as the law in Tennessee is, where there is no prevailing party status in a 41.01 non-suit, then that would not happen as much. People wouldn't be afraid to non-suit a case when it needed to be so. As far as the counterclaim argument on the policy, public policy against considering an answer a counterclaim, I think that specifically, again, you're going to have courts that are overloaded with cases, and you get into this Ouroboros of legal reasoning when you do that. If I file a petition and then you file a response that simply says I want attorney's fees and doesn't ask for anything else, does it attack my claim in any way other than just saying denial and I want attorney's fees, and that stands alone as a counterclaim, then I'm going to have to file an answer to you. And then you're going to have to file an answer to me. And we're going to go back and forth and back and forth. And it's never ending. That doesn't sound like solid legal reasoning to allow that alone. And in fact, the case law says it does not stand alone in that. And I wanted to, excuse me, that is the Blake case that stands for that. And it says, a counterclaim, on the other hand, is not a procedural mechanism. Rather, it's an affirmative pleading that is sufficient to state a claim for relief. This is from the Flade versus Shelbyville case, quoting Blake. In Blake, the court held that the employer's prayer for relief could have been brought as an original complaint. And the reason why in that specific case it said that was because there were more things asked for in the answer than just attorney's fees. And then at the end of the Flade versus City of Shelbyville case, it says, by contrast, it was referring to a comparison to Texas law, done a very good analysis in that case. The Tennessee Rules of Civil Procedure 4.01 does not explicitly provide for the survival of any pending claim or relief or motions for sanctions, attorney's fees, or costs following a voluntary non-suit. And that case is from February 24th, 2023, so somewhat new. And that, again, specifically for attorney's fees, which is the narrow issue in this case. Additionally, a counterclaim has to in some way counterattack. And in order for that to be as well in this specific facts of this case, Mr. Colley would have not been provided any due process notice because the court decided in its order after the hearing to sua sponte say, yes, this survives. There was no, and this acts pretty much as, I guess, an outstanding counterclaim or an outstanding motion. Which you know the motion can't survive the non-suit. It would have to be a counterclaim. And in that case, there was no chance for my client to have a response to a counterclaim. There was no chance for my client to argue that. Because had one been
Did your client
filed.
file a response to the motion?
The
Alter or
motion,
amend?
we did, to alter or amend, we did. But that was, again, after the voluntary non-suit was taken. If November 6th, the voluntary non-suit.
I understand that, but you're saying you didn't have your client didn't have an opportunity to address the issues. Didn't that filing give you the opportunity to address the issues?
To alter or amend,
Yes.
there was a hearing involving that issue and did argue that you couldn't have the attorney's fees in a non-suit, in the capacity of a non-suit.
Well, and you also filed a written response, correct? Or,
Yes,
or
absolutely,
attorney,
absolutely.
Attorney. Okay. And you had a hearing on it.
Yes.
So isn't that due process?
Had it been timely filed, yes, it would have given my client a right.
But you didn't even raise the timely filed issue until today.
That is correct. And thank you all. If there's any other questions, happy to take them.
Thank you, counsel.
Thank you.
Appreciate your argument.
Have a good afternoon.
I want to briefly address the subject matter jurisdiction issue, which is news to me. Trial court's decision is not final until a claim for attorney's fees is adjudicated. So there is no subject matter jurisdiction defect here. I can't give you the exact case that comes from, but I know it was litigated in Nandagam Neurology versus Beavers because it happened to be our case and we litigated it there. But finality is not achieved until a claim for attorney's fees is adjudicated. Chief Justice Kirby, this statute encourages good behavior by defendants and discourages bad behavior by plaintiffs. Just want to emphasize again, this is paragraph 22 of my client's answer here. Respondent denies that respondent, it's a misstatement, is entitled to any of the relief sought in his prayer for relief other than terminating alimony and the life insurance requirement when she remarries in March 2019, to which she will agree and would have agreed if asked without filing a petition. In other words, when you're a defendant and there is a legitimate basis for somebody wanting to modify something, this statute encourages you to play nicely. It also discourages plaintiffs from filing bogus litigation because they will end up paying for it if they do. Justice Tarwater, the answer to your question is that there is no difference at all if this had been litigated and they lost on the merits versus non-suited. In either case, the result is the same. Her alimony award remains intact and unmodified. Also note, in response to your question of me earlier, the discretionary component of the statute, the may component, should deal with any concerns about unreasonably deterring non-suits, right? If there is some outside, I can't even contemplate what it would be, maybe run out of money or whatever, reason to non-suit that has nothing to do with the merits of the claim, that has nothing to do with anything in the litigation, there is still discretion for a trial court to decline to award attorney's fees. So there is, if you have a genuine basis for non-suiting, it's not like you are automatically going to end up paying a fee award. I want to circle back to the fact that when you are a defendant who has already won a consent decree, your goal is to preserve the status quo, period. The idea that someone who succeeds in doing that, maintaining their alimony award, maintaining their child support award, would not be considered prevailing when they succeed in doing exactly what they want to do makes no sense. I do want to correct an error in my brief before I sit down. Discovered it last night. Page 18 of our principal brief says that the trial court awarded my client fees based on both the provision of the MDA and 365103C. That is not correct. I apologize for that. He said it was a good argument, but the trial court ruled on a different ground, so this is something that this court would have to consider in the first instance. As to whether or not my client is the prevailing party, we submit that she is as a matter of law. I want to again ask this court to decide this on the narrowest ground available. Now, I should say that I still think we win under the standard the government, or under the issue that the government has briefed here, the broader issue of whether defendants in original litigation are prevailing parties when a plaintiff non-suits. But that affects a whole lot of people, that broader issue, who are not here, do not know that their interests are in play. So I'm going to encourage this court to issue its ruling on the narrowest ground available. The fact that when you're in the context of post-judgment litigation, and the defendant has already won a consent decree, already won a merits judgment in original litigation, and there is a post-judgment effort to modify it, that person does not need to win on the merits again in order to maintain their prevailing party status going forward.
Do we need to go even that far, or should it be narrower still? I guess you've suggested we should look at the MDA provision rather than the statute, but even if we rule on statutory grounds, would you suggest sort of limiting it to this narrow family law context, or do you think, would you urge a ruling that is broader than that, that would apply more generally to prevailing party? The interpretation of prevailing party.
I think the statute does it for you. Just the statute itself is almost uniformly concerned with post-judgment context, right? So it deals with contempt actions. There necessarily has to be an order in place. It deals with decrees of alimony or child support. There necessarily has to be an order in place. So I think the statute does that for you. It narrows it to this family law context. But yeah, that's what this case is. So you don't necessarily need to have a broader holding than that. I think the holding is correct. I think it's fairly uncontroversial as a matter of federal law that you don't need to prevail twice. But yes, I think that it is perfectly fine to narrowly hold in this specific context under this specific statute that you don't need to prevail again. Thank you, Your Honors.
Thank you both, counsel, for your arguments. Call the next case, please. Oh, yeah. We're going to take a short break.
All rise.